All right, we are back on Morning Line. Thanks for joining us. Our guest is Jennifer Thompson. She was the attorney for Emanuel Samson in our gavel-to-gavel case that just ended in the Antioch Church Shooting case. He was convicted, of course, will be serving the rest of his life behind bars. Not completely over. There's still going to be a sentencing phase, maybe in July, for the other charges he was convicted of.
That's right.
Okay, but the biggie was charge number 4.
Right, the life in prison without parole or with parole.
Okay.
After 51 years.
In his case, and you wanted to present more of this, and I know there was some frustration you weren't able to. What is it you think you want to share or say about mental health and how it's treated in our judicial system?
Well, I think in our case, the court followed the Tennessee law, and the Tennessee law says that, I mean, it's very harsh. So in terms of having anybody else come and testify about whether or not he suffered from, the law uses the term mental disease. So if you wanted to have Dr. Montgomery, for example, testify at the guilt-innocence phase, which I think is important. You're asking a jury to make really big decisions, and I think it's fair to the jurors to have as much accurate, truthful information as possible when they're trying to make their decision. And so the jury really should know if he has a mental disease, if he's mentally ill, if he's suffering from schizoaffective disorder. I think that's really important information for the jury to know. And it was key to our defense. But the law says, and this is where I think it's unfair, that unless your doctor can say, because it really, you know, there's 2 parts to a crime. There's the thing that you do, and then there's the thing that you're thinking. So in a homicide, somebody's killed, but just calling it a homicide alone doesn't account for what the person is thinking at the time. So once you go to, well, what were they thinking, it becomes a first-degree murder, a second-degree murder, criminally negligent homicide, voluntary manslaughter, or reckless homicide. So what they're thinking at the time is very important. Well, unless your doctor that you brought in can say to a definitive absolute, unless the doctor can say, I absolutely know that this person could not form premeditation because of their mental disease, the doctor can't testify at all. And what doctor, within reasonable doctor, is going to ever say for certain what somebody's thinking?
It's impossible to know that for sure.
You can never know for sure what somebody's thinking. You can, I mean, even the jury doesn't know absolutely. They look at all the clues. Doctors can look at medical clues and try to decide if somebody's judgment is impaired.
Okay, and I understand this, but I think a lot of the questions folks will have on this is, in your opinion then, if the law changes to allow more testimony that way, are you saying that if it's proven that someone suffers from the type of mental illness you're saying, that they should be absolved of what they did?
No, I'm saying the jury should know those facts, and the jury should use those facts in weighing everything and deciding. It's the jury that decides what kind of weight to give people.
Sure.
And it's not black and white. Just because you suffer from bipolar disorder or schizophrenia doesn't mean you're absolved from everything. But I think it affects people's mental processes and thinking, and it's an important fact to know when you're deciding something. Just like a confession is an important fact.
Under law, that is an interesting point, and we'll see if they address it. And as far as premeditation, which you say is very key, I mean, doesn't it take premeditation to plan suicide? So right there, the guy was premeditating, and if you're arguing that Samson was going to kill himself, well, he's premeditating that, isn't he?
You know, premeditation under the law is really defined so vaguely. Premeditation is done after cool judgment and reflection. Okay, so you can't be in a heated moment of things. So maybe when people are deciding whether or not to commit suicide, they are so passionate in the heat of the moment, they haven't had time to coolly reflect and use judgment as to what it is they want to do. You know, so maybe that's the difference between assisted suicide if somebody has cancer and they know they're not going to recover, and somebody who's very, very depressed and psychotic and is delusional at the time. You know, they're not using cool judgment and clear reflection to decide what they want to do.
All right, let's take a call from Ray. Ray, good morning. What's on your mind, Ray?
Yeah, I want to know why that when they try a black person or a Spanish person or somebody of a different race, that they don't use the same color judge or the same color juries or defender, rather than using white people you see more white people in the trials than you do black people. And it looks like to me the state would have somebody to defend the guy that was a black person, or somebody to prosecute the guy that was a black person.
Okay, well, yeah, that's a whole lesson in voir dire and selecting. You were involved in the selection of the jury. By the way, this demographic, I don't know which four were excused as, the alternates, but was the breakdown? I understand there were some blacks on the jury. There were some whites.
Four African Americans, and there were 12 total that ended up sitting. So it would have been a.
But it was a mixed bag. I mean, it should. Your jury should reflect, don't you think, the community you're from to some degree?
Well, ideally, that you would want it to. If you have 20% African American population, you'd want your jury to be 20% African American, I'd say.
Mm-hmm. Yeah, but again, we should explain it that you and the prosecution went through a voir dire where you selected jurors. Some were excused, some you said, I'd like this one, and that's the way it worked out, right?
Right, yes. So it's a combination. We got to strike some people for cause if it kind of became clear from questioning that they wouldn't be able to be fair. Mm-hmm. And then we got to strike some people for preference. That we just thought, well, they just might not do as good of a job for us. They didn't necessarily have the qualities we were looking for.
Gotcha. Let's take another one from Charles. Charles, good morning. Hi, Charles.
Yeah.
Yeah.
This has nothing to do with mental illness. I understand this gentleman was from Kenya, and Kenya is a violent country where you have to be militant to survive.
It's not from Kenya.
Right. He's from Sudan. His family, he left Sudan when he was just about 3 months old, but his family were Christians in Sudan, and at the time it was majority Muslim, and so there was a lot of killing of Christians and kind of torturing, killing, and kind of ethnic cleansing. And the whole country was in a war over it. Mm-hmm. And his family, because they were Christians and being tormented, escaped. They first escaped to Egypt, and then they later were able to come to the United States
as refugees.
And I think generational trauma has a lot to do with his parenting. I think the family, I mean, they had seen relatives killed, they had been threatened themselves, they had had really, really hard war crimes committed against them. And I think if you're just talking about a parent and how tolerant they can be, or how understanding somebody could be, a lot of that has to do with whether or not they're suffering and whether or not they have seen a lot of dangers and bad things that they haven't gotten therapy over.
All right. I'm wondering, as we cover these cases gavel to gavel, are you even aware of the camera being in there? Does it affect you? Do you think it affects your client or the prosecution or the judge? And you've had cases, obviously, where cameras haven't been there, and then you've been involved with two really high-profile ones that have. I'm just curious what your take is on that.
Well, I don't think about the camera, really. I'm so focused on the jury and really looking at the jury, trying to decide from their facial expressions, are they understanding what I'm saying? Is what I'm saying making the, is it connecting with them? Mm-hmm. So I'm not noticing the camera. And I have to be honest, I don't look at any of the online comments while I'm in the middle of a trial, because it would
just I mean, there's
throw me off too much.
There's a lot of strong, online comments. People, like I said, they can be critical,
and having my mind focused on what other people are thinking about me personally doesn't help me with my client's defense.
Well, does that matter to you? What they think?
In general, a little
people
bit.
want to be liked, but I mean, you take on these cases, and you have to know a lot of people are frustrated that you do or whatever. It's not right that they do, but you represent some pretty awful people.
Well, here's how I see it. The Bible, Jesus said to people, what you do unto the least of these, you do unto me. And these people said, well, when were you in prison and we didn't visit you? When were you without clothes and we didn't clothe you? When were you sick and we didn't care for you? And Jesus said, what you do unto the least of these, you do unto me. So I honestly believe that if I take care of somebody that's the least of men, somebody that society doesn't respect, somebody society thinks is terrible, isn't that kind of a Christian thing to do, to take care of those people and show them kindness and goodness?
All right, people ask themselves that. Certainly everyone's entitled to a legal defense. We'll take a break. When we come back, more of your phone calls and a few more comments is our final segment with Jennifer Thompson. Very interesting conversation. Back right after this.